Hi, everyone, and thank you for joining us at the Legal HR Summit. The Legal HR Summit is a two-day online event hosted by Ius Laboris, the largest employment law alliance in the world. This session is part of the Americas block and is the last one of our event. I am now turning over to Sami Assad to begin the session. Go ahead, Sami, you're welcome to start.
Thank you, Isadora. Hello, everybody. Um, I'm very excited to be with you all, and I'm looking forward to diving into this very interesting topic. I'm Sami Assad. I'm a partner with the U.S. National Labor and Employment Law Firm of Ford Harrison. I work closely with business leaders throughout the U.S. to develop practical solutions to the broad range of legal challenges that employers face in managing a modern workplace, including the issues we will be talking about today. With me are Raul Toscano. He is HR head of Americas countries at Credit Suisse. Raul joined Credit Suisse in 2005 as head of the Human Resources Department for Mexico. Over the years, his role expanded to cover HR for Latin America countries, except for Brazil and the Bahamas. He's currently the HR head of Americas countries, which excludes Canada and Belize. Is that right, Raul? Okay. And Raul serves as a member of the board of directors of Credit Suisse's legal entities, and he also leads several philanthropic and social efforts. Also with us is Jorge de Fresno. Jorge is a partner at Basham Ringe Correa in Mexico City. He's been engaged in the practice of labor, employment, and social security law, and is a trial lawyer, as well as a strategist and counselor. He is a member of multiple legal associations, both in Mexico and the United States. According to the Latin American Corporate Counsel Association, Jorge has one of the, quote, most highly regarded labor law practices in Mexico City, close quote. So I'm honored to be on this panel with these very esteemed gentlemen. So we're now going to take a look at our agenda. Okay, and this is the only slide that we're going to have here. And it's just to set the stage for what we have ahead of us. After this brief introduction, we're going to go right into the remote workplace and some of the issues there. Specifically, we're going to talk about responsibility for the cost of equipment and other expenses, safety, and protecting the company's confidential proprietary information. We'll then move on to pay issues, and then we will briefly talk about disability accommodation, which is mostly an issue in the US under the Americans with Disabilities Act. Just as a quick reminder, please do ask questions, use the Q&A box at the bottom. As you can see, we don't have Q&A at the end. We're going to integrate it during our discussion. You can take down that slide, Isadora, thanks. So just as a quick intro, due to this pandemic, companies throughout the world were forced to implement remote work. A lot of employers discovered that this is actually beneficial and want to make it a permanent solution for several positions. Other employers can't wait for it to be over so they can return to normal and terminate remote work arrangements. Given the status of the pandemic, remote work is going to be around for some time, perhaps at least through next year. In the time that we have together, we are just going to identify and discuss some of the issues that arise from remote work. Before we get moving though into our first topic, we have two quick polling questions. If Isadora can put those up. So there's just two questions. If you could please submit your response. Before the pandemic, did your company have any employees who worked remotely on a permanent basis, whether full-time or part-time? It's just yes or no. And number two, going forward after the pandemic, God willing, do you intend to allow remote work for some positions on a permanent basis? Yes or no? Please just quickly respond, and we'll put those responses up on the screen right now. Okay, look at that. So before the pandemic, 50% of respondents had remote work on some level. 50% did not. And then going forward, the majority of those who responded do intend to allow remote work on some sort of permanent basis. So this is a really relevant discussion, and thank you for responding to that. So let's dive right in and talk about the remote workplace. And the first topic is the responsibility for costs of equipment and other expenses. And we're going to start with Raul.
Thank you very much, Sam. Well, certainly this pandemic situation changed our environment in many ways. All of a sudden, we start having a new environment we need to face. Our homes became not just our homes, but also our offices, our classrooms, and too many other things. So that has been an important change in the environment. And itself, the concept of employment had changed already and have been changing due to the dynamic and the economy and due to the requirements of the different sectors. And that also has been impacting and creating different issues. Um, there's in reality, in the majority of the Latin American countries, there's no formal, real, in place rules. Some exist, but are not really utilized, and some others have not having the impact that was expected. Not just from due to the dynamic that we used to have as a traditional legacy of the concept of employment, but also due to the fact that not all the countries in all the locations have the same capability to have access to remote working. Even talking about uh, Wi-Fi connections, computers, etc. So in not too many jurisdictions has these things, and not all of them has a good implementation of those rules. One example that we can take into consideration it's in Chile. Chile has a solid law indicating that the employer has the obligation to provide all the access, all the facilities, and all the utilities that the employee needs to do this, what they call teletrabajo. The remote working, it's different, appreciated in other industries and in other countries. And we have some other cases, such as in Canada, that also you have the ability to deduct from your tax income report the space that you're utilizing for business purposes or to allocate the remote working. Some other companies have been providing to their employees support and subsidies in order to achieve this accommodation, because it's an important topic around this new reality that we have in face of us. That's in general terms what I can mention. Certainly, there's a lot of things to do, and not all the rules are adequate and up to date in terms of what we're facing now. And it's an important challenge that we have in front of us when the governments try to over-regulate the instructions, the indications, the requirements. It's where something can be complicated at a point that are trying to substitute what the most important thing I believe in the employment and relations with the people, which is the mutual agreement. So this is something that it's important to take into consideration. But that's it on general terms.
Thank you, Raul. Jorge, let's hear about how things are in Mexico with regard to expenses and equipment for working remotely.
Excellent. Thank you very much, Sammy. A pleasure to join this panel with my good friend Raul Toscano, with you, Isadora, and all of our friends from our great alliance, Use Labores. Well, Mexico has regulated remote work. That's how we call it, remote work, and that includes certainly all sort of work or activities that are not performed within the employer's facilities. That is, the employee may choose whether he or she may want to work in her home, in his home, or in any other place. So, nevertheless, Mexico did regulate remote work in general, as I was saying, since 1988. But the regulations have proven to be limited. That is, they were not up to the standards that have been needed during this pandemic. And oddly enough, they are not up to the standards that will be needed going forward, as we saw in the poll that most of the companies or attendees at this webinar are looking forward to continue with remote work. No, so Having said that, the law is silent. Mexican law is silent as to whether or not the employer has to provide working tools in the specific chapter of remote work. In let's say in regular employment relationships, it is the employer's obligation to provide or supply employees with adequate working tools. This is not the case for remote work. The law, as I said, is it's completely silent. So since the law is silent, this has left everything to the parties to agree on how the working tools, expenses, and other terms and conditions of employment in the remote work or home office, as we popularly describe it, have to be taken care of. No, and in as much as possible, yes, the employer has to provide the working tools and pay for the expenses. Nevertheless, it's not a statutory obligation. As I said before, the regulation of remote work or home office is very, very limited in Mexico. And that is why, as we speak, there are currently 14 legislative bills pending in our Congress, most of them trying to regulate several items. Number one, yes, working tools. Number two, the right to disconnect. Number three, how the employer has to look at safety concerns within for the employees within the new work environment, and of course the payment of utilities and other needs by which the employee has to incur and the employer take care of. This is in general, and since we have a very limited time here, well, we may better address the questions that may come from the audience, but that's the general frame right now.
Great, thank you, Jorge. I'll just say that as far as in the United States, this topic of expenses and equipment is tackled at both the state level and the federal level to a limited extent. At the state level, there are a few states that directly address when employers have to reimburse employees for expenses incurred. States include California, Illinois, Montana, Iowa, and New Hampshire. These states have some specific statutes. California, for instance, says that anytime an employee incurs an expense on behalf of the employer is obligated to reimburse the employer for that expense. And if not, there are penalties, and they're pretty steep. What about other states? Other states either don't have wage regulations at all, or they have a general wage regulation that says, for instance, employers have to pay all wages in full and in a timely manner. A lot of state statutes will also limit when an employer can take a deduction from an employee's paycheck. Now, these states don't address expenses for things like internet or cell phone, but Massachusetts, for instance, has had a decision come out earlier this year. It wasn't in the context of the pandemic, but it involved travel expenses. And the employees framed the question as saying, well, our employer did not reimburse us for our travel expenses. Therefore, our employer did not pay us full wages. And the employer tried to dismiss that suit, saying, wait a minute, there is no statute that mandates reimbursement of expenses. And the judge denied the motion to dismiss, saying, wait a minute, the law does say you have to pay full wages. So if you diverted wages in a sense by allowing the employee to incur an expense that was yours employer, you potentially failed to pay the employee's wages. So it's an interesting argument, and I expect to see plaintiffs' attorneys using this type of argument in other states that don't mandate reimbursement of expenses to say, you know, by not paying expenses, by forcing the employee to incur a variety of expenses to operate from home or remotely, in essence, the employer is failing to pay wages. Federal law doesn't address this directly either, but federal law does say that an employer has to pay federal minimum wage. And if an employee is incurring expenses to the point that the employee is not receiving minimum wage for all hours worked, it could potentially be a violation of federal law. So it is an interesting question, as Raul has noted in other countries and Jorge has noted in Mexico. It seems like this new way of doing business was not anticipated by the law everywhere. And so therefore, we're trying to see how old law is going to interact with a new way of doing things. And hopefully we'll get some guidance going forward. Let's move on to the topic of workplace safety. I'll go ahead and just start because in the US, this is pretty easy. You may know that in the United States, there is the Federal Occupational Safety and Health Administration, OSHA, which regulates workplace safety. OSHA, going all the way back to the year 2000, has taken the position that when employees are working from home, OSHA is basically staying out of it. They will not inspect an employee's home, and OSHA does not expect employers to inspect employees' homes either. So essentially, where safety is concerned, the employee is, the employer is not obligated to ensure safety in an employee's house. And the federal government is staying out of that. Jorge, what are you seeing in Mexico on this topic?
Well, this is something in which, this is subject in which our law is not silent.
Okay.
We have a system or a regime that covers workers' compensation in Mexico, and it is called the Social Security regime. There is an institute, which is the Mexican Institute for Social Security, that takes care of everything related to workers' health, occupational health, and the security of the workplace. Every employer, by virtue of having employees at his or her services, has the obligation to register employees before the Social Security Institute and pay the respective dues. Dues are paid tripartite. That is, the employer pays the thickest part of the dues, then the government pays a lesser portion, and the employees pay the least part of this. But this covers any hazard that may occur in any type of employment relationship, regardless of whether or not the employee was performing his or her work, or it was in transit, for example. The difference here is that the hazard, the accident, may be deemed to be an occupational hazard or a non-work related incident, which goes directly to impact the employer's degree of risk, which is the basis for the employer to pay the respective dues, because that is what the Social Security Institute will need to invest or pay to take care of the employee in any related incident. Therefore, in Mexico, even if the employee is working out of the facilities of the company or somewhere else, he or she is covered by our National Social Security Institute, and the employer bound to pay the respective dues. So yes, there is protection for employees working remotely.
I should mention that is true in the US as well, as far as injuries are concerned. Employers, employees who get hurt working remotely or anywhere else for that matter, if they're working, they're covered by our system in the US called workers' compensation. Are there anything in the rest of the countries, Raul, as far as the employer having an obligation to ensure safety in the workplace itself, like having ergonomic chairs and having adequate lighting, or an environment free of hazards, things along those lines?
It's pretty similar as described by you and by Jorge. The governments and different labor institutions have the obligations to ensure that the employers are providing with the necessary healthy environments to perform their jobs. One of the things that we are evidencing through this pandemic time is on the fact that uh, it's chasing and challenging the barriers or and how we can ensure the safety environment at home on the employees. That's something that has been happening. And while the different systems in the different jurisdictions cover as well that part of the risk, it will be a challenge to define why and when it's created by the result of the performance of the job and when happens due to the regular day-to-day activities of an employee at their homes. So it's very interesting that approach. As a matter of fact, there's a challenge currently taking place in some of the countries, saying that the labor department might have the ability to go into your home to get the inspection and to ensure that your employer is ensuring that you're having a safety environment.
Hmm.
That is certainly going to be a challenge. There's some other constitutional rights that might be getting into the scope and the arena and saying, hey, listen, why, when you are going to be having the capacity as an authority or as my employer to get into my home to validate the safety environment that I have here because we're working on a remote basis.
Right.
So it's a challenging and very interesting topic that it's starting having discussions around that.
Yeah, which is very interesting. And Sammy, please allow me to jump in here because notwithstanding that in Mexico, labor authorities and social security authorities do have the ability to inspect and become aware of whether or not the employer is really taking care of the health of the employees in the workplace. They have not been doing it, nor there is any intention in Mexico, at least in all of the bills that are pending before Congress, to provide the authorities with such ability, you know? And so it is very, very interesting. And regarding, ergonomic chairs or suitable space for work and things like that, which also go to affect or benefit the employee's health, there's nothing about it right now in Mexico either. Therefore, it comes always, as I said at the beginning, to the agreement between the parties. Sorry to jump in.
No, that's very helpful. Thank you for adding that. Let's move on to the topic of protecting the company's proprietary information. Banking institutions, healthcare employers have a lot of private information, proprietary information, and what happens when employees have this information on their computer at home, where they're sharing space with friends, family members. Let's start with Raul. You're at Credit Suisse, financial institution. Does this keep you up at night?
Yeah, it's a challenge because certainly there's no way that you can ensure that at all times you're having the same level of protection towards the information. At the same time, I believe that as I've been telling through this presentation, that the most important thing and element that we have in front of us is the agreement with our employees to keep to provide to ensure the adherence to the different principles, policies, guidelines, to ensure that the proprietary information, the sensitive information, and any privileged information, especially at certain industries or activities of the economy, it's fundamental. It's fundamental, and clearly it's a challenge. It's a challenge because now, since you are remote working, the majority of the employees, it's practically impossible to ensure if at some point I take up from my chair and I leave everything at everybody's side. We cannot ensure that other than being sure that we are having an open discussions with our employees, that we're providing a constant information about the importance of ensuring the appropriate management of that, to ensuring that the adherence to the corporate principles and the philosophy of the company, and relying and having confidence in our employees that they will act at the best interest of the company, our investors, our clients, and our employees themselves.
Jorge, how about you?
Yeah, it is a challenge here in Mexico. Secrecy, confidentiality are obligations of the employee. not just as a matter of law, but as a matter of agreement. As you all know, in most employment agreements, the employee is always bound to protect that proprietary information, trade secrets, and certainly not to disclose it. But as Raul said, well, that information is now running around my house. And even with pandemic or not, well, there are people approaching your home and you receive guests, etc. I mean, God forbid it, but even your wife, or your husband, etc. No, so it is a challenge, and the employer does have to really protect that information in as much as possible, not only in employment agreements or as a matter of law, which is again an obligation. In Mexico, based on the intellectual property law, there are certain crimes that are classified when an employee violates or bounds or infringes that obligation of secrecy. If the employee discloses trade secrets or any other type of proprietary information, well, he or she may be committing a crime. So what we're doing right now is make sure that the employee in the remote work environment does not only know that he or she is bound as a matter of law and as a matter of contractual agreement to these obligations, but also what could happen if we find out that that information is running around in places where it shouldn't be running around. But again, it is a challenge, Sammy.
Yeah, I agree. And I think here in the US, there's a couple of considerations that employers really should think about. And again, this is from the standpoint of the employers who did not prepare for remote work, were not thinking about remote work, and suddenly they're forced to adopt remote work. Let's start with the laws, right? There are laws that protect trade secrets in the United States. There is the Uniform Trade Secrets Act that has been adopted by several jurisdictions. There's also the Federal Defend Trade Secrets Act. And one of the features of these laws is in order for something to be regarded by a court as a trade secret, the court's going to look at what measures did the employer take to protect those items, that information. And if the employer didn't take any measures to protect it, then the court is not going to give you, perhaps will not give you protection. So you want to make sure if you have proprietary information, confidential information, don't just rely on the fact that there is a law, and don't just rely on your confidentiality agreement, which you should have, but you got to really take a look at your practical measures to ensure that confidentiality. Sure, people are in their homes. It's tough to regulate what goes on in their homes, especially in the United States with the constitutional rights that we have. But are you providing training? A lot of companies, for example, are providing cybersecurity training. What about ensuring that that training covers things like how you handle confidential information when you're home, using the features of your computer, hitting Windows L to lock your screen when you step away from it, making sure to use VPNs or Citrix or some sort of thing so that the company's files are not being downloaded onto the local server or the local machine, the local hard drive, or being shared without some sort of tracking. As an attorney at a law firm, we have all kinds of protections. I can't look at a file without the law firm knowing that I looked at it, right? This may be technology that your typical corporation might not be using, but maybe now you have to if you're going to have remote work. So you definitely want to take a look at how you're handling these things and what information you're putting out to workers and what training you're providing, so that an employee who you do trust, who's trustworthy, doesn't simply just for lack of knowledge, lack of insight, allow confidential information to be viewed. I'll also just mention that there are laws in the US about data breaches, or what happens when certain confidential information of third parties, like individual social security numbers or driver's licenses, personal information, if it is disclosed inadvertently, there are some obligations in several states as far as notifying the public and things like that. Let me just take a minute here. We do have some questions coming in, and thank you for those that are submitting questions. We will try to get to these as best as we can. Here's a question about Interesting question. What are you seeing as trends regarding international remote work? Meaning if an employee is asking to work remotely from another country. Raul, I imagine this may be something you're seeing where you have an employee in one country who says, well, since I don't have to report to work, I want to go back to my native country, let's say, and I want to work for, you know, a Brazilian company out of Bolivia or something like that.
Yeah, a very interesting topic and a very complex topic to respond. There's not just one single answer. Certainly, some kind of flexibility might be provided now with this environment, but at the same time, we need to consider that there's not just a single element on the individual employment relationship and the mutual agreement that we might subscribe with an individual. There's some other laws and some other things that we need to take into consideration. Data protection is one of the most important things that we need to evaluate. Cross-border and transfer data, it's another very important topic. And also due to the emphasis that the different government has been having and the necessity of the governments to continue collecting incomes from the formal employees and employers, the BEPS phenomenon will take also an important point into the consideration. If I am a resident in the US or in Mexico or in Bahamas or in any other country, but I want to render services from my original country, for example, here in Mexico, we need to take into consideration a lot of things, not just the mutual agreement or the facility or the possibility that exists. Then I believe there's not just one single answer, and we need certainly to be prepared and better aligned with the different laws, and the different laws need to be aligned in a different way to allow this interaction and this new reality. As I said, the concept of employment had changed already, had been changing over the past years, and the pandemic situation becomes a most powerful agent of change as they force us to see the things in a different way. But there's not just one single answer. I believe that we need to continue monitoring on that, but basically the laws, the codes, and the regulations that exist might impact the possibility of providing different multi-country approaches when you're rendering services to a particular employee.
Very, very interesting. And just for time's sake here, I want us just to move on. And there was a question about this, but it's going to come up now with pay issues. Paying workers who are working remotely, when you can't see them, they can't come in to the office, punch the clock, work, punch out, and then go home. How is this being handled as far as tracking working time and avoiding unauthorized working time, making sure workers are only working when they're supposed to be working, when they're scheduled to work? And Jorge, why don't we start with you as far as Mexico? What is Mexican law on this topic?
Sure, absolutely. Let me just go back a little bit to the remote work from abroad. Raul's explanation was excellent, and yes, there's no single answer, but more so, Mexican law does not regulate that at all. So, and I had a case, and I don't want to expand a lot about this, about a CEO of a major company that has a beach house in Mexico, in Los Cabos, to be more precise. And he asked the board to allow him to work from there. And the answer was yes. But here, different elements, and I want to go a little fast to go to the other question, come into play, like immigration laws, you know, as Raul said, transfer of information, cross-border transfer of information, et cetera, no? So since the law is silent, you may, in Mexico, really agree with the employee that notwithstanding that he or she is a Mexican national bound to a Mexican employment agreement, he or she may be allowed to work from Las Vegas, for example. You know what I mean? Which is really no violation to the law. Going back to the other question, well, yeah, time tracking and compensating employees, it is an issue as well, no? Most companies using information technology have the ability to really track work, but not in as much as the companies would like to, because Well, most of these companies would just track when the employee logs in or when the employee logs out, but not really if the employee is actually working or delivering the work that he or she was hired to perform. You know? So that may be an issue in some jurisdictions where you have hourly pay. Mexico is really not that big of a problem. I mean, the supervision or the lack of supervision is a problem in Mexico because of what I just said, but not really the payment, because in Mexico, we agree on monthly salaries most of the times, no? So the employee may really not be doing anything, but the employee is entitled to that to the salary, you know. So it really becomes a challenge to track time working and to track the delivery or the compliance of the obligation that the employee has to comply with. No, now this takes me to the other item. I mean, the right to disconnect. What if the employee works beyond those agreed hours and goes and really asked for the payment of overtime, but there's no way to track these hours? No, in Mexico, that's a big issue. I mean, it may become very, very expensive for an employer to pay overtime in a constant basis. And the only way to avoid this is really to set timekeeping systems or to agree expressly that the employee may not work beyond those agreed hours.
Okay, very, very helpful. Raul, how about in other Latin American countries? Are there regulations as far as tracking hours worked, or is it also a monthly salary approach?
Well, it depends on the country, certainly. In some countries, it's established as Jorge indicated. In some others, you need to track hourly. It's a complex situation now, especially when they're working remotely. The rendered services or the rendered time means that I am logged in, connected to the network, and how about if they take a break a moment, the connection is stopped at that time, then it's a really challenge processes to track. There's no other way at this point, and on my perspective at least, to track that working hours. It's really difficult, and it's better to stay attached to what it's indicated on different labor dispositions and codes, because if not, we're going to try to reinvent the wheel, but at the same time, we're not going to be having any legal grounds or any support to establish that the connection time, it's like being active on your social web media. I'm on all the time. Does that mean that I've been working all the time, 24/7, more than 18 hours, more than 12 hours? That's something really difficult to track. And I'd rather to stay attached to what the code says, as Jorge indicated. It's better approach. It's more safe approach. But also that introduced this topic into a very important element, the health and safety and the work-life balance of our employees. Because we need to ensure that while managing a different environment now, we're at the same time taking care of all our employees to ensure that we're having and preserving and giving them the opportunity to maintain an appropriate work-life balance. We need to be sure on that, and it's our responsibility to help them and to help us to keep our people, one, motivated, to not get into the point of stress, but also that implies another topic, such as the International Work Organization established a principle of safety, healthy, and work-life balance. Mexico recently introduced it's called Norma 035, which is enforceable now, and it's intended as well to evaluate that part of the processes, the healthy, the safeness, and to keep also the productivity of the employees.
Yeah.
Sorry, I deviate, but it's important to get
that's good. You actually
with,
answered one of the questions that had come up about that NOM. I'll just say this in the US, tracking time is a big issue here because federal law mandates that most employees, those who are non-exempt, meaning in shorthand, non-salaried, frontline workers, oftentimes, they have to be paid for all hours worked, which means you have to track hours worked. And you have to pay overtime for hours over 40 hours in a week. So this could be a whole entire topic all by itself, but I'll just say this, employers definitely have to take into account both that broad federal law as well as some unique state laws. California, for instance, has overtime after 8 hours in a day, and some other states have some unique rules as well. But it is incumbent upon the employer to put measures in place to control when work is done and when it is not. The topic, the legal concept in the federal law is called suffer or permit. So anytime an employer allows an employee to work, not merely requires an employee to work, but allows an employee to work, you have to pay for that. Which is to say, if you don't want to pay for work, then you have to prohibit work off the clock. And it's not enough. Jorge, you mentioned putting a policy that says you're not allowed to work off the clock. Absolutely great idea, but it is not sufficient. When, for instance, you have a worker who then says, yeah, I know what the policy says, but my supervisor called me at 6 o'clock and said, I need to get XYZ accomplished tonight. I couldn't wait till tomorrow. And also you have technology that can show that an employee was responding to emails after hours, responding to texts after hours. So you need to have controls, you need to have policies to management that says, don't text your employees after hours, don't email them or put in your email, to be answered, during work hours or something like that. Because if you don't control it, you're paying for it. We are down to 5 minutes here, and I just want to spend a couple minutes on this topic of accommodating disabilities and remote work serving as a potential accommodation. In the US, we have what's called the Americans with Disabilities Act, and many states have parallel state laws that mirror this. And that law requires that an employee who has a disability can request for an accommodation to enable him or her to perform the essential functions of the job. And employers have to at least engage in what's called the interactive process. You have to have a discussion. You can't just shut it down and find out what the employee needs. So suppose post-pandemic, an employee says, I have social anxiety disorder, or I have an immunodeficiency disability of some sort, and I can't come into the workplace. I need to do my job from home. Can I do this job from home? And the employer may be saying, well, wait a minute. I thought we were done with all this remote work stuff. Pandemic's over. Why do I have to continue this? Well, an employer will have to engage in that dialogue. And the one key thing to keep in mind is the fact that we have done work from home for months now, maybe a year by the time such a question arises, may make it difficult for an employer to say, I cannot allow you to work from home. It would pose an undue hardship. It may be difficult to say it poses an undue hardship because you just did it for 6, 7, 8, 9 months. If you want to take the position that it poses an undue hardship, you might want to be prepared to say, even though we did allow it for some limited time because we were forced by legal mandates, it destroyed us as far as productivity, or we lost a ton of revenue, and we cannot sustain that on any sort of long-term basis. But just something that you want to keep in mind, because now we have all sampled remote work, and we need to think about that as far as when an accommodation request is made. Any final thoughts, Raul or Jorge, about anything we have not mentioned? And then we'll turn it over to Isadora.
Oh, no, Sammy, it's been a pleasure, Raul, Sammy. I mean, what I can say is that remote work, home office, is here to stay. We saw the results of the poll at the beginning of this panel. And if legislation or case law does not provide elements for us to regulate remote work, well, that will leave everything to the agreement between the parties. And one of the most important things that I've been successful in doing is really trusting the counterpart. If you have trust in what the other party is doing and what the other party intends to do, your relationship will be successful.
Yeah, I think that's very wise. And I would say the employers who get ahead of the curve, who really embrace remote work, at least in part, at least I was just speaking to another employer and I was saying, at least think about it as plan B. If you're in the group that said we don't want remote work after this is over, you might want to still have some plan B for remote work, because we never know when such a crisis may arise again, or some other need may arise, or as an accommodation or something like that. Being prepared, having remote work policies, thinking through these issues of time, confidentiality, productivity, tracking, all of these metrics will help you in the long run, and you won't be caught facing, this unprepared. So thank you, everybody. It's been great to present with you.
Thank you very much to all. Just as a final comment, what is a challenge now might be an opportunity. The remote working can provide our people, our employees, and all of us the capacity to have a better work-life balance in communities and countries and cities such as Brazil, Mexico, and others. The traffic, the transit, the dangers, the other assaults and things like that are exposed to our employees every day. And now with this remote working capacity, they're in a more safe environment. They do not have to do this commuting. And what we see as a risk, a challenge, can be an opportunity. And from a cost perspective as well, the companies can have a lot of savings by doing this remote working efficiently, smart, and thinking and on a better way to continue with the improvement of productivity and with improving with the work-life balance of our employees. I think that will be my closing comment. And thank you very much. It's an honor for me to be with you, Jorge, with you, Sami. Thank you very much.
Thank you, Raul. Same here. Thank you, Sami.
Thank you, Sami, and gracias, Jorge and Raul. We have now reached the end of the session, which was also the last one of the Legal HR Summit. I would like to thank you everyone for attending the summit, and thanks also to all our panelists for their important insights. I hope you have found the Legal HR Summit useful. Thank you and goodbye.